Hello everyone and welcome to the channel Ontario Law and the Older Person. And in this particular video, we're going to be focusing on ageism in employment when it comes to hiring. The warning: the information provided in this video is not legal advice. It is relayed for the purposes of general information. No legal decisions should be made based on this material. Any viewer who needs legal advice should contact a lawyer. Back to the Human Rights Code, always a place to start. Section 5, Employment, subsection 1. Every person has a right to equal treatment with respect to employment without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. This is the list of grounds about discrimination in the statute. That's all I'm doing. I'm reading them out. So don't look at this list and think, oh, I have a lawsuit. If you feel that you are being discriminated against, definitely contact a lawyer. Okay, harassment in employment, subsection 2. Every person who is an employee has a right to freedom from harassment in the workplace by the employer or agent of the employer or by another employee, something to remember, because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. Section 23, subsection 1. The right under Section 5 to equal treatment with respect to employment is infringed where an invitation to apply for employment or an advertisement in connection with employment is published or displayed that directly or indirectly classifies or indicates qualifications by a prohibited ground of discrimination. So that's going to include age. Subsection 2, the right under Section 5 to equal treatment with respect to employment is infringed where a form of application for employment is used or a written or oral inquiry is made of an applicant that directly or indirectly classifies or indicates qualifications by a prohibited ground of discrimination, including age. Now, an issue with these is that it's very hard to prove, and there's not a lot of case law or even discussion about it. Subsection 3, nothing in subsection 2 precludes the asking of questions at a personal employment interview concerning a prohibited ground of discrimination where discrimination on such ground is permitted under this act. So it's discrimination except when it's not. Isn't law great? And then subsection 4, the right under section 5 to equal treatment with respect to employment is infringed where an employment agency discriminates against a person because of a prohibitive ground of discrimination in receiving, classifying, disposing of, or otherwise acting upon applications for its services, or in referring an applicant or applicants to an employer or agent of an employer. So really just, the type of companies that contact you know, some kind of agency to work on their behalf to hire people. The same rules apply to that agent. This is an article from the Canley website. That's where you can find it. Legal barriers to age discrimination in hiring complaints. And yes, this is old, 2016. And the thing is, when you try to look up about this issue, what you're usually going to get are some blogs from different legal websites, and usually they're not very complete. So even though this is old, I still think its ideas are relevant. A direct quote, studies have shown that employers are often reluctant to hire senior workers for various reasons other than age per se, such as high labor cost or proximity to retirement. For example, some employers will be less inclined to hire senior workers who are perceived as more expensive than younger workers, having higher wages, more costly pension and health benefits, and there being less time to recoup the firm's investment in their recruitment and training. The difficulty is that while many employers genuinely appreciate the experience and expertise of senior workers, they may still choose not to hire them for these other reasons. So I have a bit of a question here. It's been a while since this was published, and of course, the information that they're referring to, studies, will be older than 2016. So my question here, we are seeing a lot more so-called entry-level positions where like the old days, the pay is really low, but now people are expecting these candidates to have lots of experience and higher levels of education than such kind of jobs would have in the past. So information that would be useful to me, I think, is this ageism still taking place when a lot of these factors, such as a good salary and benefits, are no longer in play? Something to think about. Age discrimination cases are unique in that it is very common to justify discrimination through business-related reasons. A similar claim against the high labor cost of people with disabilities or pregnant women is generally not acceptable as a rational or reasonable reason for discrimination. Even if hiring people with disabilities or pregnant women is costly or requires accommodation, employers are expected to bear this cost as long as it does not amount to undue hardship. But when it comes to senior workers, a cost-based claim is often acceptable. Another quote, part of the underlying reasons these claims are more acceptable in age cases is that age discrimination is considered different from other forms of discrimination. Furthermore, there is a common perception of a tension between protecting the rights of senior workers and the needs of younger workers. As youth unemployment becomes a major concern, there is a growing perception that increasing the employment of senior workers reduces job opportunities for younger workers. However, extensive empirical research has refuted this perception. Now, again, this was written in 2016, which means the research is probably going to be older than 2016. Where are things now? To address that last issue, I went to this website, the Investopedia website, and the link is in the description. What this discussion about thinking if older people stay in the workforce, younger people can't get in, it's the lump of labor fallacy. And if you were to Google the definition, that is what you're most likely to see. Older workers staying in the workforce means younger workers can't get in. So this has a slightly different definition, which is why I'm going to it. Also, this is from December 2024, so it's more recent material. So the definition on the Investopedia website is the lump of labor fallacy is the mistaken belief that there is a fixed amount of work available in the economy and that increasing the number of workers decreases the amount of work available for everyone else or vice versa. So actually this website is talking about immigration. I wanted to see if there was a bit more up-to-date research on older workers keeping out younger workers. So I found this website, the OECD website, the Employment Outlook for 2025. Can we get through the demographic crunch? And again, the link is in the description. And I just went to one footnote to discuss this issue. So in the article, they were saying that research has shown that maintaining employment among older workers doesn't keep out younger workers. So I'm just going to this footnote to address that issue a little bit. So in this footnote, we have some research from 2022 and 2023 finding that delaying retirement reduces opportunities for younger workers in the same firm, while we have information from 2021 that it is the opposite, possibly due to the benefits of age diversity for productivity. And we're going to have to go to that source in order to find out what exactly that means. But I'm not going to do this for this video because if I go diving into other research, video will be huge. Okay, and then we have research from 2023 that finds reduced demand for young workers through delayed retirement, but also they find a small positive effect on labor productivity in the short run. And again, we're probably have to going to go there if we want to see exactly what that means. But the point here is to indicate and show that the situation might not be quite as cut and dried as people thought back in 2016. All right, going back to the Human Rights Commission of Ontario's website, and the link is in the description. So we're focusing on employment here. A direct quote from the website, older workers face significant barriers in finding employment. These can take the form of overt discrimination, such as not hiring someone simply because of his or her age, or more subtle or systemic discrimination, such as eliminating someone because of a perception he or she lacks career potential. Such barriers can be compounded for persons who belong to groups that face their own barriers in accessing employment, such as racialized persons, newcomers to Canada, and persons with disabilities. Another direct quote, whether the discrimination is overt or systemic, the code protects individuals against discrimination on the basis of age in the hiring process. The code prohibits a job advertisement that directly or indirectly classifies or indicates qualifications by age. Refer to the section. Similarly, application forms and oral questions must not directly or indirectly classify or indicate qualifications on the basis of age. However, during an employment interview, questions may be asked about age, provided that drawing a distinction on the basis of age is permitted under the code. And again, we see, oh, this is discrimination, except when it's not. So the website says, in an advertisement, statements that directly or indirectly relate to age should be avoided. Nothing should unfairly prevent or discourage an older worker from applying for a job. Requirements or duties for employment should be reasonable, genuine, and directly related to the performance of the job. Here is another report from the federal, provincial, territorial ministers responsible for seniors, and this report is called Older Workers, Exploring and Addressing Stereotypes. It is from 2022, and the link is in the description. A direct quote, employers should not use biased, exclusive words and phrases in job postings and avoid language such as energetic, mature, and highly experienced, or reference to number of years experience, etc. So here's the thing. If you look at job ads from law firms, they almost always specify how much experience they want this person to have. 1 to 3 years, 10 years, senior partner. So is that discrimination, or is that a legitimate requirement when they're seeking someone for these jobs? Okay, another quote. In organizations where negative stereotypes are more common, such as finance, insurance, and information technology, greater effort can be made to reflect older workers in the recruitment process. For example, recruiting advertisements could feature older workers at computers using the company gym and so forth. Using the company gym. Wow. But talking about computer-related technology. I'm not going to give his name, but there was a guy who pretty much set himself up for discrimination lawsuits by claiming you shouldn't hire anyone over the age of 30 or something like that. While I was putting this video together, I decided to check Indeed Canada, see some job descriptions. I'm not naming the business, and I suspect when you watch this video, their job ads will be taken down because I am pointing out there might be some problems with their advertisement. And so this is for a part-time bridal consultant. I haven't put in all the details, but seriously, reading this job ad, it looks like someone is being expected to do 2 or 3 different jobs. So from the ad, detail-oriented with the ability to handle multiple tasks in a fast-paced environment. Now, it seems nowadays every job is a fast-paced environment. Is this language going to be off-putting to older people or people who have disabilities? We don't even know what it means in this context, a fast-paced environment, what those multiple tasks will be. Will this give people with disabilities or older people the sensation that they're not looking for me? I can't handle a fast pace. Or am I being ableist and ageist, even mentioning that this might have a chilling effect? So, do you think this is a problematic paragraph or not? And then we have flexibility to work evenings, weekends, and holidays to accommodate bridal appointments and events. Now, in another video, I talked about direct versus adverse effect discrimination. So direct discrimination is when they are intentionally putting together a policy that locks certain groups of people out. On the other hand, adverse effect discrimination is when there's a policy that is neutral or objective that has the effect of locking certain people out, not the intention. So this is probably a neutral policy or an objective policy that's applied on anyone who works there. You all have to be available for these kinds of shifts. However, could it have a harsher impact on older people? So think about it. Who is more likely to have the ability to accommodate a schedule like this? Basically, jumping around, not necessarily being able to make long-term plans. And would this have an impact on caregiving responsibilities, right? If you can't say from week to week to week, hey, this is what I can do. I can take grandma to her doctor's appointment, something like that. So would a younger person have fewer responsibilities, taking care of their own kids, taking care of their parents, and therefore be able to jump around like this, where an older person might have more care responsibilities, taking care of their kids, taking care of their parents? Or am I just reading something into this and younger people will have responsibilities, older people will have fewer responsibilities depending on their life choices? So, does this have the impact of keeping older people out, or is it a truly neutral policy that doesn't have a discriminatory effect? Here's another ad, and this job requires a lot of walking around. Not going to name the business or define the job more than that, but this is text straight from the ad. So part-time students welcome. So right off the bat. And sure, a student can be any age. Older people go back to school, but think about it. If someone hears the word student, are they going to think younger person versus older person? What's more likely? And then in the rest of this text, I have bolded students just to bring it to your attention. It's not bolded like this in the original ad. So this role is perfect for students or anyone looking for strong communication experience, sales skills, and weekly bonuses. So if someone were to be challenged on this, and please don't challenge people based on what I'm saying, just based on this wording, um, someone might be able to say, well, we're not limiting it to students, anyone looking for strong communication, etc. So then why do they mention students at all? And then what you'll do, skipped a bunch of stuff in the description. I did work alongside a supportive high energy student team. So now we have high energy, which might have a chilling effect, and then student. And then while you'll love this job, skipped a bunch, work with other students. Why is that more appealing than working with anyone else? So do you think this ad is problematic, or am I reading too much into it? Back to the website of the Human Rights Commission of Ontario. So from the website, on an application form. While a form may ask, are you 18 years or older and less than 65 years of age? I talked about a statute where basically the protections are limited to 18 to 64. It should not ask any other questions about or relating to age or date of birth. The form should not request copies of documents that indicate age. Some employers may even choose not to ask when schooling was completed, as this may often indicate age. Okay, is that a practical expectation? What if you're expected to hand over a copy of your school transcript? What if you're expected to show proof of some kind of certification? So sometimes I think the Human Rights Commission has requirements that might not actually be practical in a real world setting. Still on the same website, quote, during an interview, questions relating to age should only be asked if a code defense applies, such as where a special program is in place, employment is aimed specifically at persons 65 or older, the employer is a special interest organization serving a particular age group, or age is a BFR, and that refers to a bona fide occupational requirement. This is a human rights tribunal decision, and the applicant, Reese, and the respondent, business that shall not be named. It's named in the original text. It's just I'll be criticizing it in this video. If you want to see the whole story, well, there's the citation, how you can find it on Canly. And I hope I'm pronouncing that first name, Reese, properly. Might not be. From the first paragraph of the decision, Peter Reese is a lawyer who is 60 years of age, cut out some stuff, dot, dot, dot. In 2011, the respondent, which is the company, had 2 vacancies for the position of commercial legal writer. The applicant applied for the position but was not selected for testing or an interview. He alleges that he was not considered because of discrimination on the basis of age. And in the very first video, I pointed out that who is an older worker can be determined by the nature of the industry. So sometimes a younger person is older in this industry, not in another, but 60 years of age, that's pretty much across the board. That would be considered an older worker, which is a red flag. I'm also taking out the names of the people involved that were employed by the company. So this is from paragraph 6. Ms. X, who is an employee of the company, explained the general recruitment process. When a vacancy comes up, she first confirms with the Human Resources Department that the vacancy can be filled. The job is then posted. The Human Resources Department does an initial screen of the applicants and then passes the potential candidates to her for review. She then selects any that she feels should go forward. These candidates are invited to come for testing, which includes a writing assignment to show that the candidate has the necessary writing skills. Candidates who pass the testing stage are invited for an interview. This is from paragraph 8. Ms. X testified that it can be very difficult to fill a writer position. Skip some stuff, dot, dot, dot. Ms. X testified that there is also a relatively high turnover of writers and that it can be difficult to retain people. This is because of the fluid nature of the business and also because the remuneration is relatively low for people who hold a law degree. So yeah, does that seem like a place you would want to work at? You know, high turnover, always a bad sign. And what does fluid nature of the business even mean? Paragraph 18. The applicant intentionally omitted some information from the CV he submitted with the job application, including the date of his call to the bar, that's when students become lawyers, and the dates of his earlier jobs. The applicant testified that he omitted these dates to avoid highlighting his age. He said this practice had been recommended at a seminar he attended that discussed challenges and strategies for job candidates over 45. 19. In addition to the omission of dates, the CV indicated that the applicant was in private practice from 2005 to present, but did not indicate whether the private practice was with a firm or if he was a sole practitioner. At the hearing, the applicant agreed that he should have provided clearer information on this point. Paragraph 21. The applicant's CV and covering letter were reviewed by Mr. Y, a consultant from an external agency working with the company, on May 18, 2011, the same day they were sent. Mr. Y responded on the same day and asked the applicant about his salary expectations. The applicant replied later on May 18 that he was not familiar with writers' salaries, but that he would hope for a salary between $39,000 and $49,000, but that benefits, of course, would play a role. Mr. Y replied to the applicant and told him of the benefit package, and the applicant responded that the package sounded good and asked Mr. Y to proceed. This is not a paragraph from the case, it's my summary here. Ms. X found the lack of dates and details about the private practice to be red flags. They needed the years to evaluate experience, and to her, this deficiency in the resume might be a sign of deficiencies in other areas. Also, they thought the low expectations for a salary from such a senior lawyer was odd. They asked the candidate to provide another resume with the added information, and he did. And I've always found the whole approach of, oh, we're not going to tell you what the job is worth. We want you to tell us, a toxic trait. I've always hated it. To me, it is a dodgy practice. And here we have a situation where you're damned if you do and you're damned if you don't. If he asked for too much money, they would think, oh, he's too entitled, he's a jerk, we're not going to hire him. But he asked for too little, and now they're suspicious because of that. So I am very glad that the law has changed in Ontario in that the ads, in certain situations at least, have to include the salary. Despite the updated resume, those in the recruitment process still found the candidate's approach problematic and that he might be overqualified. It was decided to put his application on hold while they considered other candidates. The other candidates had the requisite experience and were ultimately offered the jobs at a higher salary than the applicant had asked for. A summary from me. At one point during these events, the applicant contacted Mr. Y asking when he was getting an interview. Mr. Y at one point sent the candidate an email claiming they had decided against the applicant and that they were looking for more junior applicants. At the time this email was sent, neither of these things were true. Paragraph 86. The effect of Mr. Y's communication to the applicant was that the applicant had no reason to follow up with the respondent. Had he been told that his application was on hold, he would very likely have followed up. Given what happened with, I'm filling that in there, two other candidates, one quickly quit, the other turned down the offer, he was then the only qualified candidate from the recruitment process. Accordingly, even though Mr. Y was not the ultimate decision maker, his communication had an adverse effect on the applicant. A bit from paragraph 99, not the whole paragraph. While I refers to the panelists making this decision, agree that overqualification can provide a discriminatory pretext if a person is in fact overqualified for a job. That fact can create genuine, non-discriminatory reasons for not offering employment, regardless of the person's age. So let's take the person's age right out of this. It's like, who cares if someone is overqualified as long as they can do the job and they're willing to take, orders and willing to take the salary? Like, who cares? Paragraph 100. In the case before me, that's a panelist, I do not see the fact that Ms. X identified the applicant as overqualified as evidence of discrimination. The significance of the applicant's overqualification was that he had worked for many years in a senior corporate law position. Given this, Ms. X was not clear why the applicant would want to instead work as a legal writer at a low salary. Again, while the applicant had a very good explanation for these concerns, which would have likely satisfied Ms. X at an interview, the applicant had not been forthcoming, to use Ms. X's term, in explaining why he was applying for the job, given his background. So what? Let him have an interview and give him a chance to explain. Why not? He had the qualifications. Why not check it out? Paragraph 102. I find that the applicant has established some evidence to support his contention that Ms. X's decision making was influenced by age discrimination. However, the applicant has to do more than this. He must establish that it is more probable than not that his age was a factor in Ms. X's decision making. I find that he has not done this. The evidence indicates to me that Ms. X consistently had questions about the applicant and whether he would be a suitable candidate. I find this opinion a little problematic. So he did have evidence, but it wasn't enough. And the panelists seem to be saying, oh, because there's evidence that she had these other issues, that means there's not enough evidence of age discrimination. I find this a little difficult, and I feel bad for the applicant. If he does have some evidence, I think to me that's enough to demonstrate ageism had a part to play. But here we are. This is what the result of the panel is. Paragraph 108. For the reasons noted earlier, I find that a reasonable inference from the evidence concerning Mr. Y's involvement is that he personally had formed the opinion that the applicant was not a suitable candidate, based on a stereotypical view about the applicant based in part on the applicant's age. We don't really have detail here about exactly what stereotype was in play. Anyways, continuing. The result of this was that the applicant thought that he had been rejected and did not follow up. I find that Mr. Y's communications to the applicant were tainted by age discrimination and that this had an adverse effect on the applicant. Paragraph 109. However, the adverse effect was limited because Mr. Y was not the decision maker. The effect was limited to depriving the applicant of an opportunity to follow up. This is very different than discrimination resulting in not being interviewed at all or not offered a job. And really, is it that different? This was a gatekeeping function. It stopped him getting access to an interview that would have allowed him to explain all of the issues that Ms. X had with his application. So is it different, or are we just really splitting hairs here? Paragraph 111. I find that the applicant is not entitled to monetary compensation for any loss of earnings because I have found that the applicant has not established that Ms. X discriminated against him on the basis of age. I disagree. And because it was Ms. X who was the decision maker. 112. I find that the applicant is entitled to monetary compensation for injury to dignity, feelings, and self respect as a result of the discrimination, resulting in Mr. Wise giving the applicant incorrect information about the status of his job application. Paragraph 113. It is difficult to quantify this injury. In itself, incorrect information about the status of a job application would not lead to a higher end award. However, the applicant was clearly upset about not being considered for the job, and this information came from Mr. Y. It was the information from Mr. Y that caused the applicant to file the application. If the applicant had followed up, he might well have got an interview. And what do you think? Do you think that would have been a likely scenario? It seems to me like Ms. X had already made up her mind. And to the point where even though he was the last standing qualified candidate, she still didn't want to talk to him. So I don't know if I agree with this panelist's interpretation of events. And then paragraph 114, in consideration of the circumstances, I conclude that the applicant is entitled to $5,000 as monetary compensation for injury to dignity, feelings, and self-respect. This is my wrap up. Ms. X got a bad impression of the applicant due to his resume and wage expectations and didn't seem to let further information adjust her position. So I'm getting vibes of Pride and Prejudice here, except there are no tall, handsome men or witty conversations. Even after the candidates quit the job or turned down the offer, he was the only one there who had the right qualifications, and she still wouldn't have a conversation with him. So, would you want to work here? Someone who just ignores other information, even when it's in their best interest to get that information, admitting it's hard to get writers and to keep them. And yeah, I think he dodged a bullet here and he got $5,000 out of it. So this is the end of this video. This is just talking about hiring, right? And it's half an hour. And this is why I decided to split up all the employment videos into separate sections as I have, because the others are probably going to be half an hour too. So thank you for getting to the end of the video. Have a great day.